Very happy Wednesday to everyone. It's a beautiful day and welcome to our September Advisors Forum, part of the Elville webinar series. My name is Jeff Stauffer, Community Relations Director with Elville & Associates, and I'll be your moderator for today. Today's topic is Planning in Politics, how the advisory team can best help clients during the upcoming 2023-2024 political cycle. Your presenter today is Elville & Associates Managing Principal and Lead Attorney Stephen Elville. So again, welcome everyone, and Steve, thanks for your time today and your knowledge. We have several new advisors on today's forum, so I'll explain how this will work. We encourage your general questions and thoughts for the discussion, so please note them at any time on our questions panel on your screen, and we will take time throughout the presentation to address them. Your questions and thoughts really add value, they help others learn, so don't be shy in posing your questions at any time. You also received the presentation slides by email from me this morning to take notes if you wish. The slides are also available in the section marked handouts on your screen to download at this time. For CFPs, CPAs, and most other professionals on today's webinar, you may receive 1.5 continuing education hours for attending. And per my attendance records requirements on my end, please send me your ID number if applicable, and I will submit your CE hours for approval and also send certificates out tomorrow morning. Everyone will also receive a post-webinar feedback email right after the presentation, so please be sure to send this back to us and just take a couple minutes to fill out this very brief survey to offer us your feedback about today's presentation. We have a lot going on here at Elville & Associates, and we have more than we can even begin to share, but a few highlights. We just hired a couple of new additional attorneys to further support our busy estate and trust administration and elder law departments. We have our biggest and best event of the year in our annual client and community education event coming up on November 4th at 10 Oaks Ballroom in Clarksville. This year's theme is asset protection, protecting your legacy and the ones you love. We would love to see you there. If you haven't heard about it, I'll be sending some information out in my follow-up message that I send out after every webinar and forum. And lastly, we have our annual social event for our client care program tomorrow evening. We're going to be welcoming our members and some employees to the Orioles game versus Tampa Bay tomorrow. So we'll all be having a fun time out there with our members and our employees. Looking forward to that. So briefly, we have a lot to cover, and Steve has a lot of thoughts to share. So I want to give a brief overview of our firm and offer Steve a proper introduction. You should be able to see my screen here. Steve Elville and Elville & Associates, we were founded in 2010 in Columbia by Stephen Elville. We have several different practice areas that we offer here at the firm: estate and special needs planning, elder law and elder care planning, estate and trust administration, business law and succession planning, guardianship and litigation, tax planning and asset protection. We have 9 attorneys, 12 staff members in 5 locations. Steve and I are coming to you live from the Columbia Gateway Community location today. Our mission, as it always has been and always will be, is to provide practical solutions to our clients' needs through counseling, client education, and the use of superior legal technical knowledge. And we do focus on education a lot here at Elville & Associates. We do that in several ways through our planning processes with our clients. We offer many webinars and workshops in the communities that we serve each year. And also by way of our accredited client care program that I alluded to earlier, we are one of only 2 firms in Maryland to have an accredited client care program accredited by the Client Care Academy in Boston. We also work with the ideals of client education, collaboration, and compassion in mind every day with every client here at Elville & Associates. Just a bit about Steve. His work as an attorney the past 20+ years has been centered in elder law, special needs planning, and estate planning. A member of many different national professional organizations, he works to bring peace of mind to clients by offering solutions to their needs through counseling, client education, and the use of leading-edge legal technical knowledge. A very seasoned speaker. If you haven't heard Steve present before, presenting at many workshops and webinars for businesses and their employees, conferences, and continuing education events each year. Steve was also named to the Maryland Super Lawyers list for an 8th time in 2023 and a 7th consecutive year. He also had a feature story written about him in the Maryland National Super Lawyers magazine about the Elville Center for the Creative Arts, which is our firm's charitable organization he founded in 2014. And I'm very privileged to be the executive director of. So if you'd like to learn more about the Elville Center, please feel free to reach out to me directly at any time when we have a little bit more time, and I'd love to share our story with you. But for right now, we have our advisors forum to get to, and Steve, I'm going to make you the presenter.
Thank you so much, Jeff.
You're very welcome. Thank you.
I will take control of the screen now, and thank you so much again. Hello, everyone, and happy Wednesday to everyone. And I'm going to be efficient here today. I know that you are very, very busy. And this morning I was just commenting to Jeff, gosh, it's a very, very busy day. So I'll be efficient, and I appreciate your time and your willingness to spend your time to support our advisor forum. Without you, we could not actually do this. So hello, welcome, and we're going to get into some material today that I thought was extremely relevant, and obviously you do too, or you wouldn't be here today. And I think we have several goals in mind in this presentation. Obviously, there's a lot of political and social unrest in this country. There are a lot of people divided, and this is a hot topic that we have to be very careful with, even among ourselves, to be productive and to be honest and to try to do what I hope to do here today, which is to help clients and their families suffer less. Just getting my screen squared away here again. To help clients and families suffer less, to help people cross this bridge that they seem to be up against. And I'm going to share some stories with you. I'm going to invite you to share some stories if you have them, practice stories, because my opinion is that if you haven't experienced this yet, to my opinion, you certainly will experience the conflict that can occur in your own practice, or that you'll see the conflict that's occurring with people and how we want to deal with it. So my goal here is to help at least one person cross this bridge without having to stumble across that bridge, to help the advisory team to collaborate about this issue, and to help families suffer less. So I thought this topic had merit. We're going to get into it. But before I do, I'm just going to ask Jeff a really important question about the Orioles game tomorrow night. Jeff, who will win? I can't help myself. Ketchup, mustard, or relish? So,
you know, I'm going to have to go with ketchup.
Okay,
I'd say probably it's about a third, 1 in 3 shot.
Very good. I just wanted to make sure we cover that before we get started. Okay, my attempt at humor, and so now we'll get started. And let me go to my slideshow actually, and we'll play from the start and get into our presentation. Again, I thank you for being here, and we look forward to talking to you after this presentation. So this is not legal advice, and of course this is going to be very subjective. This can't even be considered to be professional advice, because it's in a way it is, and in a way it isn't. It's almost personal advice, and it's a personal forum for us to share with each other as advisors, CPAs, financial advisors, life insurance specialists, attorneys, as we talk about this particular issue. So what are we going to talk about? Well, we're going to talk about the current legislative environment and what we can expect, at least for planning and income tax and estate tax through 23 and 24. We're going to talk about the main thrust, which is the client attitudes that we're seeing, client behavior, client fears relating to political unrest and social unrest. And this obviously has been going on for quite some time, but I'm seeing it manifest in different ways. You may be seeing that as well. Being prepared and being proactive. And I think the only way we can do that is to get our heads out of the sand if we haven't already done so. And I hate to say be hyper aware of what's happening, because I think just being aware in the regular sense is not going to quite get us where we want to be. And I will share some examples with you. We're going to talk about how political polarization is affecting families in planning today, at least on the estate planning side, as you think about that for your clients, and you very much think about what lawyers and what team members would be best to help you and your clients. Identifying family and fiduciary problems in advance. So that I think this is clearly a new mandate for us. Now, I don't think it's a new job. I think it's a new mandate. I think we can do the old job and we can still get this job done of identifying problems in advance. Understanding special fiduciary roles in estate planning, and how can these help? How can these tools help us as we're seeing clients that are dealing with these anxieties and these angers and these polarizations? Understanding mediative tools in estate planning and how to minimize conflict We can't always minimize conflict, but we certainly can do our best to try. Understanding increased client demand for independent fiduciary services. Many of you are aware of this. Many of you are asked to serve in fiduciary roles, and some of you are allowed to through your broker dealers and parent corporations. Some of you are not allowed to, some of you want to, and some of you don't want to, but I'm going to have a little bit of an opinion that I'll share with you about this. How to keep clients grounded, how to keep families fundamentally grounded regardless of their persuasions for politics, and understanding our collaboration as advisors and what we can do in our own way to restore or maintain confidence. All right, well, let's get into the main material now. So what can we expect in 2023 and 2024? Well, there's lots of information out there. I know you have your sources, but I just want to assure you that we continue to be in a very favorable estate tax and estate planning and income tax planning environment in estate planning. So we have the sunset proposed in 2026 for the estate tax to cut in half and be adjusted up to around 6.7 to 6.8 million is what we anticipate if this actually occurs. It is legislatively set to occur on January 1st, 2026. And some of our colleagues who practice nationally and in some of the asset protection jurisdictions in this country, they actually believe this is more of a possibility now than it ever has been. But who knows what will happen politically? We need to be aware that we still have a very favorable $12.920,000 federal estate tax, and Maryland a $5 million state estate tax. And we have this unified estate and gift tax. The annual exclusion from gift tax will probably increase in 2024 to $18,000 per person from $17,000. Couples especially have great income tax advantages, but so do single people in planning. And advanced tools, as those of you who have watched our webinar on advanced irrevocable trust planning tools and estate tax minimization strategies, these tools are largely still available. We have the robust use of grantor trusts, and of course we have legislation that comes down every once in a while, but we don't see anything on the horizon right this moment. Now, with that said, we do have new Maryland legislation. In elder law, we have a new statutory power of attorney that, unlike the old statutory forms that Maryland has, where those forms are enforceable by law, there is a short form and a long form. We in estate planning oftentimes use the short form in conjunction with a general power of attorney. The thing you should be aware of, if you haven't already been made aware, that in October, the statutory power of attorney will be updated to contain many more elder care related powers of gifting and divesting of assets and doing Medicaid planning. These powers are now going to be part of a statutory form, I should just say a form that anyone can access. And that form is going to be readily available, and it's not just going to be something that has to be strategically planned for in a customized way. So what you're going to be dealing with is a situation where you're going to deal with family members that have access to advanced powers by virtue of a very simple power of attorney, where I argued potentially against this statute that the average person would not understand the nature of some of these powers. So you're going to see a hit and miss kind of approach with what I consider a very, very important, if not the most important tool in estate planning, meaning the statutory power of attorney, the general durable power of attorney, but the Maryland statutory form changing to become more liberal with regard to the divestment powers. Someone who is an agent for someone else can divest that person of assets in a much quicker, straightforward fashion now that it's included in the statutory form. The spousal elective share and augmented estate, that legislation since 2020 continues to evolve, where surviving spouses have a statutory right of election for a greater portion of the deceased spouse's estate than they did in the past. The augmented estate, meaning the powers to be able to look at a broader estate than just the probate estate, and to be able to use that to one's advantage for elder care strategies remains a very, very viable tool. And medical assistance strategies are still very viable, such as the Medicaid Asset Protection Trust, the Veterans Asset Protection Trust, which leads us to a whole series of asset protection strategies that are available, the kind that can be obtained during lifetime with very little effort versus the kind that can be maintained or attained through advanced planning techniques or irrevocable trusts. So we live in a very, very favorable environment within which we now address this issue of the polarization, the anxiety among families, which is very, very striking considering that the planning environment is so robust. So let's talk about this polarization, and we're going to take a few seconds here in just a moment for you to consider this in your own practice and in your own life, and the things that you might have seen or anticipate seeing, but I'll just share a few things with you. I've seen this manifest in client questions and inquiries. So let me just tell you just how much this has manifested in my own practice. So I can be giving a workshop in person at a particular location, and it has happened to me numerous times in the past year where one of the potential attendees or attendees will approach me prior to the presentation and actually challenge me as to my political persuasion, my political affiliation, and tell me, I don't know this person from Adam, they don't know me, but they're informing me that unless I agree with them, that they're probably not going to attend. So, you know, this kind of thing is out there. I'm seeing this. I'm seeing this in the conference room with client behaviors, a client's criteria about vetting whether or not we will do planning with your firm. If your political persuasion and so forth is not the same as ours, or if we don't agree with you. So these are the things that we are seeing right up front. And some of you may have seen this in your own practices where you're meeting with clients and you're seeing yourselves being challenged, or you're seeing at a public venue someone challenging you. And I've just written down a few of my own notes on this. I mentioned direct challenges in our workshops, direct challenges in a conference room setting, people getting a temperature reading about who you are and what you're about, disparate treatment, and we're going to talk about that here in this list, disparate treatment of children because of political views of children or other beneficiaries that might differ than another person. Disagreements about charitable distributions to a particular religious organization that they used to belong to, but now there are political differences of opinion. Disagreements between siblings, obviously. This is one of the most hot areas that we're dealing with. Disagreements between siblings, and many times those siblings are fiduciaries. And capacity challenges. Parents and the challenges over their capacity. Their mental capacity to execute documents, or their mental capacity to continue to make decisions. They seem to be more attenuated. And the only thing that I can say in my experience so far that has been encouraging is that it looks like that despite some of this unrest and polarization, that sometimes because of this polarization being more political and disagreeable among people about their views, other than healthcare issues, other than financial issues that are directly relating to parents, where those trigger points sometimes cause breakdown and an ultimate guardianship of that person that could have been avoided if the children were getting along. The good news about this is, in many cases, I'm seeing some of this very nasty polarization really not rise to the level of a guardianship. So sometimes it does, sometimes it doesn't, but it doesn't seem to be triggering as much of an emotional reaction, let's say, as a healthcare decision upon which there's been a difference of opinion, or a financial decision. So it's there, it's manifesting, it's kind of boiling, but sometimes it doesn't rise to the level of a guardianship. So we have family dysfunction, we have family member isolation. I am seeing family members be isolated because of their views. Sometimes it's spoken, sometimes it's unspoken. I am seeing fiduciary selection in a much different way. I'm seeing many more children or nieces or nephews, especially children, being excluded as fiduciaries potentially. And I'll talk about this and the opportunities, whether this is a good or bad thing, we'll discuss it, but the opportunities that we have to serve as fiduciaries and whether we should take those opportunities to maybe take control of a situation that otherwise would continue to spin out of control. So fiduciary selection, we're seeing certain children just be just outright not considered to be part of that selection process. And we all know that when children are excluded as fiduciaries or beneficiaries, this is the beginning of sometimes a lot of problems. Disposition of assets, we're seeing people excluded, just like I just mentioned. Advisor collaboration and communication, okay? So we can see this among the advisors. We can see this among clients talking among their advisors. And that's why that the idea of advisor collaboration and advisor communication and identifying problems in advance, which we'll talk about in just a minute, is a key issue. And then I think we're going to have to talk about eventually advisor selection of clients. I think that more so than ever, we're going to have to look at clients and say, are these clients that we can actually help? Are these people that we can help suffer less? Are these people that we can serve? And things that, at least in my opinion, we haven't had to really address much in the past. So with all that said, I'm giving you a little bit of an overview of my experience in the last 6 to 12 months. I would like you to take maybe 60 seconds here and just think about any kind of client situation or family situation or fiduciary situation that you've dealt with, and whether you're seeing this, which I'm assuming you have, or you're thinking you're going to experience this. And if you want to, you can certainly share that with Jeff. But if you don't, we certainly do understand. But I just want you to think about this and what was your reaction? I'm going to go ahead and start the 60-second timer. And I want to give you 60 seconds just to kind of think about this. Are you seeing this? How have you reacted? Has there been anything that has gone awry? Has there been a situation that you could not have anticipated, that you did your very best with, but you still feel that it could have been handled better? How did it go? Just want to take a few seconds here to really think about this. And if you haven't experienced this, I want you to start thinking about the possibility of it and where it can occur. So we'll give about another 20 seconds on this. And by the way, even though this workshop is very non-technical in most ways, this is for CFP credit, and we hope that it is very, very valuable to you. Okay, that 60 seconds is up now. And if any of you have something to share, please share it in the chat with Jeff. If not, we will just continue to move on. Jeff will stop me. But as you were thinking there for the last 60 seconds, I want you to ask yourself something. Now, we all have common sense as advisors, and we all want the best for our clients, and we're all in business, and we all have a fiduciary duty that we are trying to fulfill, and the highest and best for all of our clients. But we're going to be neutral. We're going to be, I guess, by default, neutral. But my question to you is, are you really completely neutral? And I'm going to challenge you now, based on my experiences, to get a new set of paradigms for yourself, or a new paradigm. And what I mean by that is this. We all get ready for our meetings. We all get ready for our client interaction. We all get ready, for example, I get ready for my webinars in a certain way that I prepare. And I go through the motions of preparation. I'm going to challenge you here to go through the motions of getting prepared for your client meetings in ways that you never have. I want you to anticipate the possibility of being challenged at the most inopportune times. This could be at the beginning of an interaction. It could be with a client that you've had for years and everything has been wonderful. And all of a sudden, there's an emotional outburst from the client, perhaps, asking you your opinion on something, asking you what side of the fence you're on, an anxiety about what's happening politically with certain candidates. I want you to be aware of this. I want you to be ready for it at the beginning of meetings. I want you to be ready for it at workshops. I want you to be ready for it after meetings at any time. And I want you to ask yourself, do we have a company policy about this? Now, of course, many of you have social media policies at your company. Many of you have training at your companies for human resources purposes, really talking about avoiding biases. I believe this is another bias that we have to avoid, not only in the workplace, but clearly our focus here is for the highest and best for families and clients. I want you to set the stage for yourself. Set the stage for yourself and your team in advance. Talking points. I want you to think about these talking points, not just remaining neutral, but potentially, and this is going to be very individual to you, really telling potential clients and clients that you simply do not have any opinion about what they are asking about. And there are going to be times when this is a no-win situation. There's simply going to be no-win situation, but I promise you that if you don't address this in advance, that it will come back to bite you, and you must be prepared and you must execute on this when you're dealing with today's client in this environment. Jeff, I'm going to stop just a second to see if anyone has shared anything. It's fine if no one did, just to see if anybody has any thoughts, if they've seen this. Everything helps the presentation if anyone has any questions and so forth.
Thanks, Steve. No thoughts shared as of yet. Thank you.
Very good. Very good. And many of these are very personal to each one of us that we've experienced or we've seen, and we just want to know that we are thinking about it. So I'm going to ask you to think about asking more questions, to really probe. We've been living in a very generous time of wealth in this country, wealth increase. In the estate planning side, we've been very fortunate to deal with many people who need planning with all the issues around the world and the uncertainty in the world. But we don't want to get complacent. We want to go beneath the surface, and we want to make sure that our families have advisors, that they have a team of advisors, and that there is communication. I put on a workshop a year or so ago called How to Attain Perfection in Your Estate Planning. And also there's a webinar we have about being intentional. And in those webinars, I make the argument that we as advisors should challenge ourselves on a higher level, not just to establish relationships, not just to communicate in a surface way with other advisors that are serving the same client, but also to make it a point to be very proactive in communicating with one another, which is a very tall order. But I think in this way, we can get ahead of some of the client problems that we are facing. So let's talk about how to use special fiduciaries. And what do I mean by special fiduciaries? Well, let's talk about trustees, the types of trustees. Let's talk about fiduciary roles in general and how we can use these roles to create flexibility and hopefully through flexibility be able to make certain maneuvers, I should say, in the midst of troubled times with families to be able to minimize confusion, minimize conflict. So trustees, when they're serving in a role, they can either be interested trustees. These are people who are related to the trustee, or the beneficiary, the person who is related to the beneficiary, is an interested person, someone who is a family member, versus a trustee who is more independent. So we need to understand the differences between these family dynamics and the lack of family dynamics in that situation, and also the differences in asset protection in that situation between interested persons who are, let's say, family members, people that are not considered to be arm's length for purposes of the IRS, and independent persons, whether they are independent individuals or corporations. We need to understand that in that trustee situation, we can create flexibility through the use of trust protectors and other special fiduciaries, such as distribution advisors and so forth. And we can create this in the documents, all right? Now, with personal representatives, we can't create too much flexibility there because the old paradigm of how wills work and the register of wills works and who the executor / personal representative is and how that works, we can't be too creative there, but we can try to make sure that if there's a conflict between personal representatives, that we try to invoke the court's ability to do mediation. And there's also private mediation. We're going to talk about that. powers of attorney and how to construct those. How do we construct agents under powers of attorney? Okay, so the power of attorney, remember, by virtue of the fact that it contains many of those quintessential powers, okay, this is arguably the most important document in estate planning. So in my opinion, many of the problems that occur between families, in families, between fiduciaries and siblings and so forth, occur in the power of attorney documents and healthcare documents. So how agents are constructed, whether or not there's a mechanism for mediation, whether agents are listed in order or whether they're listed to serve individually or jointly, or whatever flexibility that can be constructed into those documents can make a huge difference. So again, Maryland has recognized the use of trust advisors and protectors since 2014, and we have to look at that. We have to look at the trust protector's role, and we have to say, how can this trust protector help with flexibility by being able to remove and replace trustees, to be able to demand an accounting, to be able to amend a trust administratively, and how far do we go with these trust protector roles so that we can build in the flexibility that might be crucial at a time of crisis, at a time of a challenge among children for capacity, a time of polarization among children where there's a disagreement about who is going to make a decision and whether or not the children will decide to elevate this conflict to a guardianship level. And of course, there's other independent fiduciaries. But the thing I want to point out here with this slide is that most estate planning documents don't get reviewed consistently. And if they are reviewed, we can identify where the documents are lacking, and we can build in flexibility mechanisms that may be very, very helpful in a time of conflict. So understanding mediative tools. So let's first look to ourselves to minimize conflict. We have this advisory team that Elville and Associates has talked so much about. And we are of the belief that there should be a financial advisor, there should be a CPA, there should be an estate planning or elder law attorney involved in that advisory team. There could be others, such as a life insurance professional. There could be a life care manager, like a geriatric care manager. All of these people and companies are involved in this team to best support clients. We want to communicate, ask questions, share information. I know this is very general, but we have to ask ourselves, do we really do this? Do we really do this the way that we could? And I'm going to give you some pointers about this here in just the next few slides. But let's think about this for a moment. Let's think about this slide here. Let's not just go through the motions here talking about minimizing conflict. Let's ask ourselves, what could we do? What could we do as an advisory team to actually communicate, not just communicate sometimes, but to actually communicate about family members, the well-being of families that we're serving, knowing that we're all on the same team. If we do see conflict, how are we communicating? Yes, there is an attorney-client relationship, and there's attorney-client privilege on our side of the fence. So we do have to have releases to share information, and you have to have releases. Are we doing that? Are we really trying to elevate our practices to a new level? I'm going to get to the benefits of this, as I always try to do. If we know someone needs mediation, if we know there's a conflict brewing, are we being proactive about it? Are we including people? Are we having an inclusive environment when we know there's a conflict? Unless our client says, no, you can't share this information. Are we being proactive to communicate and to share and to make sure that people are included? Let's take 60 seconds on this and take just some important time here to say, in our own individual practices, are we really being inclusive? Are we sharing? Let's start that 60-second timer. Where are the weaknesses in your practice, if any, in the sharing of information with the client's permission among the advisory team, trying to get ahead of conflicts, being very inclusive with the client's permission, communicating, taking our practices to a new level, I'm going to discuss family meetings here in just a moment. So remember, never in this country have we ever had so much opportunity from a certain point of view. And I think many of you would agree. And yet, in this country, never have we seen so much conflict. And hopefully, we're talking about things that add value. All right, we have about 3 seconds left. So thank you for that. And even if it was just an introspective thing that you did, that's very valuable to you, in my opinion. So because of conflict and because of the cutting out of certain children in certain family situations as fiduciaries, because of their political beliefs, or because of the tension and the polarization, there is an increased demand for fiduciary services. And those of you who work with Elville and Associates on a regular basis, you know about this. You know that advisors are being asked to serve as trustees. They're being asked to serve as agents under a power of attorney. They're being asked to serve as a trust protector. And I know some of you say, yes, I want to do that. Some of you say, no, I could do that, but I don't want to do that because of conflicts of interest. I've got an opinion about this here in just a few minutes, but these are things that are very, very important. I'm sharing with you here that clients are asking. They want to know who they can depend on. They are not necessarily sure they can depend in the traditional way on some of their family members and children. Independent trustees, right? We talked about this, an independent individual or an independent corporate trustee. And we know, and many of you know, that your broker-dealers, your underlying, I should say, trust company relationships are vying for this business. They are pressing very hard for it. And I'm here to say that it's priced right for many of you. And this is a way for you to really take advantage of the increased demand that clients are looking for from you to be able to have peace of mind that they don't have to entrust a child or other family member that they disagree with and they're having a lot of anxiety about. Whether we agree with this or not, this is the reality, but it creates opportunity for you. The structuring of agents, again, under a healthcare or financial power of attorney. This is an incredibly important thing, and there is an increased demand for independent persons to do this. Now, there are special considerations when a client says, I don't want to name my family member as my healthcare agent, and I have no one else to name as a healthcare agent. There are special considerations. So if you have a client that has that issue, we can help them cross that bridge and work through that issue through the use of professionals that are willing to serve. Structuring financial advisor provisions in estate planning documents. This is a way to bridge the problem of the client's anxiety. Remember, the client is very concerned. They are very upset about whatever they're seeing and whatever their personal view is versus what they believe they are perceiving out there with their family or other people. And so they are looking for certainty. There's an opportunity for you as the financial advisor to be included in the estate planning documents where the client can dictate or mandate that you and your company will continue to be the financial advisors for their children and their trust in the future. There's ways to do that, and some of you are aware of this and you have done this before. So again, maintaining client relationships and assets under management, not as just a business proposition for yourselves, but to understand that this is what clients want. This is what they're looking for. This is not just something that is a business model. This is something they need and something they want. So we want to help you do that. So keeping clients grounded, updating estate plans. By the way, I just realized that I had promised something in the prior slide, and I'm going to make sure that I follow through on that. I promised to provide an opinion about this. I'm going to challenge some of you who are very, very ethical people on this call, and you do not want to serve as a fiduciary. You feel it's a conflict of interest. And I understand that, and I understand the need for independence, and I understand your personal beliefs on this. I'm going to challenge you as the devil's advocate to consider or reconsider that position. Your clients trust you. Your clients come to attorneys like me, and they say, we love our financial advisor. We hold them in very, very high esteem. We hold our CPA in a very high esteem. We want this person to serve as our fiduciary. We don't want our children or our nieces and nephews or our siblings, meaning client siblings, and many times to serve. So I'm going to challenge you to rethink that, not only because you'll be able to retain more control in your own right over the assets, but you may be able to help the client bridge the gap of some of the frustration and anxiety that they have. So again, a lot of this is very esoteric, a lot of this is specific, but I'm going to ask you to reconsider that, because when you say no to your longtime client, when you could serve as a fiduciary, but you say no, it really does put that client in a little bit of a quandary, especially when they cannot rely on their own children or siblings. So updating estate plans remains one of the key things to do. Every 2 or 3 years, clients should update their plans. Clients should be part of a client care program, such as we have here at Elville and Associates. We are not in this business as far as the client care program because it's a great moneymaker, but because it is a habit. It's kind of like doing the fundamentals over and over again to make sure that we're encouraging family members to participate. This could be a way to bridge the gap. We're encouraging them to update. We're encouraging them to think through these issues and not let 2 or 3 years go by at a time with no updating, because we know how fast things can happen in today's world. We want to encourage family meetings, in our opinion, not only internal family meetings, meaning after planning is done or on a every 3 to 5 year basis, having a family meeting of all the fiduciaries and keeping the plan updated, but an external family meeting. I'm going to argue that clients should include their financial advisors, their CPAs, and their attorneys and other advisors in a family meeting setting, at least at the beginning or the outset of their planning or their updated planning time, and that the advisor team should also participate in that family meeting, not just the attorney. So this is a high set of standards I'm throwing out here. It's something I'm hoping you will have introspection about and contemplation about, helping people, again, through a very difficult time of anxiety and where they really are challenged to think in terms of who they can trust. We want to encourage clients to use letters of wishes and memorandums of intent. What is that, for those of you who don't know that? Well, you can have a will or a trust, and you could actually include a letter of wishes. This is a general set of values, goals that you can articulate and give a trustee or a fiduciary a particular set of guidelines, an informal set of guidelines that is outside of the document. For those of you with clients that have special needs children, people with disabilities, sometimes we use special needs memorandums of intent, but letters of wishes are basically statements of goals and values. For example, I've said to the trustee, distribute this money for my beneficiary's health, education, maintenance, and support. But what does that really mean in the eyes of a trustee 25 years later? Well, through this letter of wishes, we can articulate what our vision, what our intentions are for, and our purposes in the planning. And you can keep this updated. Clients can keep this updated. We want to encourage transparency. We want to encourage a unified approach. Where there is division, we want to encourage healing. And of course, this is possible in some cases, and in other cases, it is not possible. But what I have found in legal practice is holding out the possibility of this sometimes will be a self-fulfilling prophecy. Other times it will not be helpful. I'm encouraging you as part of the advisory team to hold out hope for healing, and you do that through transparency, and you do that through guidance, and you do that through hand-holding, as you probably already do many times. And encouraging written communication. I have found recently in some cases where there's division among siblings that there is at least some communication going on. I was in the office late last night with two individuals who could have devolved into a real conflict, but they chose to show up. They chose to stay connected in the conversation. They chose not to melt down. And this transparency, this ability to communicate, whether it's in person or by writing, this is a very, very good thing. And where clients or their siblings or children square off and they say, well, we are going to have lawyers. We are going to have lawyers speak for us. That doesn't necessarily mean that it has to spin out of control into a major conflict. It just simply means that the lawyers that are involved are may be able to facilitate a broader conversation. And if I didn't already say so, the advisory team can be mediative in and of itself to encourage communication and transparency. And this brings up our next slide, which is to promote and encourage the advisory team, remembering that the client wants a dream team, in my opinion. The client really does want that. Some people already have that. Some people have put that together. Some people have put it partially together. I would encourage all of us to help our clients continue to put together the missing pieces of that team, and then documenting that team and deciding who's going to run the playbook of the team, which is not easy. This demands communication, of course, and memorializing among the team what the client wants and what the results are that they want. And then, like I've said before, throughout this presentation, communicating among the team members and with the client and with their family members. Obviously, there's lots of different situations. Obviously, sometimes a family meeting will not be appropriate, but by and large, I can tell you from our experience here at Elville & Associates that family meetings are of tremendous value to the clients, and many times clients will engage our firm simply because we provide for family meetings and we see beyond just the basic planning. We see the process beyond and the education. But here's this opportunity to delve under the surface and to see where the real problems are. Obviously, if there are real conflicts between parents and their children, this family meeting may not be able to happen with all of the children. But again, communication, transparency, and holding out the hope of bridging the gap of this conflict is the goal of this presentation, which is really just to help one person or one client or one couple to be able to bridge the gap, and for us as advisors, for you as advisors, to be able to help them bridge that gap when this happens. And hopefully it will not happen in your practice, but when you see it happening the way we see it happening on our side of the fence, there will be at least a possibility of healing and being able to get past it. So we'd like to wrap this presentation up with thanking you for sitting through this. We know this is a very different kind of presentation. I felt there was merit in presenting it because I am seeing this and I assume you are seeing it, or you'll potentially see it. I'd like to meet you and I'd like to discuss collectively what we could do in your particular practice to help clients avoid conflict and to educate them. I would like to review the existing documents that your clients have. If you have issues with clients that they have to have their documents reviewed, we generally do not charge to do that and are happy to review documents for you. I'd like to connect and reconnect with some of you. If you haven't seen me and I haven't seen you in many years since COVID, I would like to meet you for lunch or breakfast and really connect about our practices and where we plan to go in the next 10 years or so. I would like to discuss forming study groups for those of you who have never done that before. It's a wonderful way to raise your practice level, to raise your knowledge level. An attorney, an insurance professional, a financial advisor, a CPA, and others can meet and form a study group at your particular place of business or at our office, and we can have an annual agenda, a year-long agenda of meeting once per month to discuss issues and raise the level of practice of everyone involved. We'd like to discuss the latest techniques with you about preserving assets under management for the long term. We'd like to discuss our portal. We are in the process of developing a portal to provide advisors with free tools and information. And lastly, we'd like to discuss techniques that we have gleaned and learned here at Elville & Associates over the last 20-some years to be able to help advisors and the advisory team accelerate and maintain their practice growth. So I thank you again for taking your time on a very busy Wednesday. Hopefully something I've shared here today is something that you can take away substantively and use in your practice. But the thing I would leave you with is that no amount of preparation is too much to be able to remain neutral, to be thinking about your company's policy, to think about your own personal policy as you are dealing with clients, being aware of what the anxiety that they're feeling, the pressure their families are under due to political polarization and other economic forces and social forces in our country, and to stay neutral under all circumstances. And again, we do our very best there, for better or for worse, but to help them bridge the gap of what they're feeling and move towards healing and move towards progress in their continued work with the advisory team. Jeff, I'm going to turn it over to you. And again, I know everybody's very busy, and we thank everyone for spending the last 50 minutes here in the discussion.
Thanks very much, Steve. Appreciate your time and your thoughts and great knowledge there. So we do want to let you know that our next advisors forum is going to be December 6th at 1 p.m. We're going to have a to be announced topic on that. So if you have some thoughts that you would like to hear about as far as a topic is concerned, please share them in our follow-up survey that you're going to be getting in just a few minutes. And if you have any thoughts you'd like to share here at the very end as we wrap up in the next minute, please do so. And as far as our upcoming presentations go for our webinar series, briefly, all of our presentations, for the most part, and I'd say 95% of them, are available for continuing education for our advisors. They don't have to be a forum to be available for CE. On Wednesday the 20th, we are going to be in person at Howard County Public Library. We do have a guest presenter to talk about Medicare, which plan is right for you. And then on Tuesday the 26th, we'll be back to the essentials, estate planning and elder law essentials with Stephen Elville at 7 o'clock. And then Wednesday the 27th, we'll be talking about legacy and charitable giving and philanthropy, again with Steve. And then on the 29th of September, to round out the month, we'll be talking about understanding estate and trust administration, again at 10 o'clock on Wednesday the 29th. So that is rounding out the month, and we'll have a busy October as well as we continue forward with our Elville webinar series. We hope to see you again here soon and look forward to seeing you hopefully sometime very soon, either at breakfast or lunch here at our office or your office. We'd love to reconnect or connect with you, as Steve mentioned, to learn how we can best serve clients together. So thanks for being part of our advisors forum today, and we look forward to seeing you again soon. Have a great day, everybody. Thanks.